Counsel for the appellant. You would be kind enough to announce your presence for the record.
Yes, good morning, Your Honors. Victoria Mazzola here for appellants.
And something I did not do for Ms. Harris, I'm going to ask you. Would you like to reserve any time for rebuttal?
Yes, could I reserve 4 minutes?
4 minutes?
Would you like to reserve any time to make the microphone work?
I mean, at this point, I don't know how they did it.
Do we have, but would you?
Guess I might be taller. Thank you so much. Perfect.
All right, 4 minutes for rebuttal. When you're ready, please proceed.
Great. This appeal boils down to one question. Does Florida's offer of judgment statute apply when, after years of contentious litigation, the circuit court ultimately found that the substantive law of another state applied? The answer is yes, for 2 reasons. First, the plain language of the statute clearly states that it applies in any civil action for damages.
Well, let me ask you about that on the front end. Didn't Southeast Floating Docks deal with that exact issue? And I can read you the quote where they talk about Bennett finding that very thing and saying that's not what the statute says. So what do you do with it?
Sure, so you're leading me into my second point, which is the holding in Southeast Floating Docks was narrower than that, and when it specifically just...
And thank you, this was all very well briefed, but what about my question? Doesn't the language of the Supreme Court opinion, doesn't that eradicate that first argument? The statute does not stand for what you claim it does, does it?
Well, no, in my opinion, when it discusses Bennett specifically, it says that it's overturning it only to the extent that it disagrees with the rest of the opinion.
Well, and I know you know this, counsel, I'm reading from the opinion, and the statute actually stated this, meaning what Bennett said, it's plain reading would supersede the choice of law by the parties. But it does not. Mm-hmm. What would you have us to do with that?
Well, I think when you read Southeast, and as in its totality, there's different portions of it where it discusses how the opinion is limited to only apply in instances where the parties have contractually agreed to the substantive law of a different state through a choice of law provision, typically. And so
So that's your fallback argument, which I understand. But as far as the statute mandating that any case brought in the state of Florida entitles the parties to utilize 768-79, you agree Floating Docks dealt with it?
Well, no, I don't agree that Floating Docks dealt with that. I believe Floating Docks only answered the question of what happens when there's a choice of law provision between the parties. In the absence of that, the plain language of the statute says that it applies in any action.
Well, I just read to you what the Supreme Court of Florida said. So you say they didn't say it?
Well, what I'm saying is that that's one line within the Supreme Court's opinion that was discussing Bennett. It wasn't the court's holding overall.
Well, let's fast forward. What you just said, that Southeast Floating Docks only applies where there's a contractual agreement to provide for some state other than the state of Florida's law to apply to a case. But what do you do with Farber? Are you familiar with Farber, the first DC Getty case, 2017? There was no agreement in that case, and an accident in Alabama. The parties agreed Alabama law applied in the state of Florida. But there was no contractual agreement because there couldn't have been. It was a simple auto accident. And the first DCA said, following Southeast Floating Docks, that because the substantive law of the state of Alabama applied to the case, 768-79 did not entitle the plaintiff in that case, cross appellant on appeal, to fees. So what do you do with Farber?
Sure, so I'm not as familiar with that case specifically, but I'd first say it's not binding on this court here because it's, of course, the first DCA. And I also would be interested to know the timing of that decision because I think
2017.
Okay.
And now it was a trouble.
Well, that makes sense, Your Honor.
I know about Florida.
Yes, and I apologize, I don't think it came up in our briefing, but I could be mistaken here. I think that case dealt with different facts than the facts at hand here, and this case that we have is the exact type of case that shows why the offer of judgment statute should apply in instances where the substantive law of another state eventually ends up applying. This case was filed over 4 years ago by Viva, the appellees here, and it was Viva who forced my clients to litigate in Florida, even though it knew that Delaware law would apply to the underlying claims eventually. And because of that, and because they forced us to litigate here, we agreed to proceed and we filed counterclaims, and then months later made a reasonable settlement offer of $3 million, even though.
And counsel, and I wanted to cut to the heart of this.
Yeah.
Essentially, I agree that this case has been utilizing the resources, the judicial resources of the state for quite some time at this point, and still is continuing to do so today. But so is your strongest argument then that it's a public policy issue? And if that is your strongest argument, is that alone a strong enough leg of the stool to overcome the substantive law argument? Where does that leave us?
Sure. So again, I think my argument is that Southeast floating docks was narrow. So taking that aside, that opinion aside, there's nothing in the plain language of the statute that says that the offer of judgment statute doesn't apply when.
But why am I looking at the statute that I think is probably still mixed in some respects of substantive and procedural aspects? I think that assuming that I'm a text person, but why am I looking at the text of a substantive statute that doesn't apply? Because I'm applying the law of another state. So what of the plain text, essentially, in this respect? Why am I piecing out substantive law that the judge has said does not apply? And it seems like at this point, there's an agreement that it doesn't apply, so.
Well, I think just because the court applied substantive law of another jurisdiction to certain claims in the underlying case doesn't mean that the offer of judgment statute isn't also available to litigants who are litigating in Florida based off of the language of the statute.
Counsel?
Sure.
I think the most directly I've seen your particular premise be described by the court was Canon Latin American Incorporated out of the Southern District of Florida. I'm going to quote, "It may very well be that the Florida Supreme Court was leaving open the door where a party litigating a case in Florida could be governed by the substantive law of another jurisdiction, but still have the benefit of the statute if it had not contracted it away in a contractual choice of law provision." They go on, however, it seems that in rejecting BDO Seidman and in answering the third question certified to the 11th Circuit in the negative, the Florida Supreme Court intended that its holding apply when the substantive law of another jurisdiction governs, regardless of whether the parties had a contractual choice of law provision. So at least the Southern District seemed to think that the Supreme Court was implying. I may be sympathetic to an argument that we should worry about what the Supreme Court said rather than what it might have meant, but I'd like you to lay out that case.
Sure. So I think that what's important in the context of Canyon is actually what came after, which is the Supreme Court's decision in Diamond Aircraft in 2013, where the same judge, Judge Lewis, who wrote Southeast Floating Docks, was answering a different question under the offer of judgment statute, but in discussing Southeast, stated, and I quote, in Southeast, we then held that when parties agreed to be bound by the substantive law of another forum, absent specific public policy concern, section 76879 has no application, which led to our conclusion that an award of attorney's fees under section 769.79 was not proper because the parties' agreement to be bound by the substantive law of another state rendered section 768.79 with no application. So given that the Supreme Court clarified its own holding in Southeast, I think that, Cannon brought up a good point that it might have been a little bit unclear, but then the Florida Supreme Court subsequently came out and clarified what it actually held previously.
So even if you were then to prevail on the idea that 768 applies where there's no contractual choice of law provision, doesn't Diamond still foreclose your case in that it seems to very strongly suggest that yours is not a case for damages?
No, and I know that's something Viva brings up in its papers. What Diamond Aircraft says is that what's required here is money entitlement and seeking money rather than equitable damages. And in our case, we filed counterclaims that were seeking monetary damages, and that's what resulted here in this case. We have a judgment for over $7 million that came out of the underlying case. So, I think we could stop there, that there are damages in this case, but I can go into some of the case law that Viva cites to.
Is it exclusively damages? Isn't your case essentially a deck action seeking who's entitled to the policy?
Well, sure, who's entitled to the policy, but really what's underlying and being sought is money there. And
how is that not a mix of both equitable and monetary relief, which Diamond includes?
Well, when you look at the cases that Diamond Aircraft cites to, it discusses how it doesn't need to be that rigid. It cited to D. Pompeo where there was where the party saw a declaration that there was no contract and that party didn't owe the other side any money. And Diamond Aircraft said, that's enough in that case. And here in the same way that Diamond Aircraft discusses how what you have to look at its heart is money entitlement, that's what's at play here. It's money, and so because of that, I submit that there are damages here, and I can touch on as well the argument that Viva makes here about injury and how they claim that there was no injury to my client here, and there is injury. These types of insurance policies that were taken off, this isn't a one-off case, these stranger-originated life insurance policies, as we call them, were taken out on thousands of elderly individuals. And there are different cases that discuss this, but insureds who have these policies taken out on them are injured in many ways. By way of example, they have less insurability, they have tax concerns, they give people large HIPAA releases to their medical information.
Giving a broad enough reading to the idea that the case has damages that would encompass just about every case and sort of obviate the distinction in the first place?
I'm sorry, could you repeat your question?
I think you're reading damages so broadly that it would encompass almost every case, in which case there's no reason to distinguish whether it be for damages or not.
My apologies. This is a separate sub-argument to damages that Viva is making, where they also claim that there's no injury here. And so what I'm doing now is just explaining that there is, insofar as you think that their claim that there's no injury has foot, I just wanted to highlight that there is injury here. And we discuss it in our papers, and I can say even all the way back to 2009, the Florida Insurance Department put out a bulletin about harm that these STOLI policies have on people. So I can kind of leave that there, that for years, states across the country, including Florida, have found that there are harm to these policies.
And Ms. Mazzola, if we could take it back Farber is not controlling on us, but Higgins potentially could be.
Sure.
Higgins is our 50 CA case. What do you make of that? There's no analysis, but the line is certainly in there, and one thing that is clear is there's no choice of law provision that is indicated in that case. So what would you have us do with that?
Sure. So the Higgins case, as you mentioned, had no analysis to it. It was only within the last line of its opinion that this court declined to award attorney's fees and cited to Southeast Floating Docks. And because there's no analysis there, I submit that it can't be binding on this court because we have no understanding of the rationale behind why the court made the decision that it did. It could have been for any number of reasons. As you all know, we're de novo here. And beyond that, I think
de novo, even in spite of our own precedent, I'm not familiar with it.
Well, no, not in spite of your own precedent, but I think within the realm. Beyond that, I think it's also important to know that timing piece that I mentioned earlier. Higgins was decided only a month after Southeast Floating Docks, so it was a very new opinion that had just come out, and it was prior to the Supreme Court clarifying isn't the right word, but describing its own opinion again almost a year later in Southeast, or in Diamond Aircraft, rather. So I think given all of that, Higgins shouldn't be binding on this court because the main point is we have no understanding of why the court ruled the way it did. And instead the court here has the opportunity to more explicitly have a decision on the topic at hand. Unless there are any further questions for me, I'll yield the remainder of my time. Thank you.
Good morning, Your Honor. Kyle Kwong of Ward Harrington and Sutcliffe here for the appellee Viva. May it please the court. I think the court has a pretty good sense already of what the ramifications of Southeast Docks is, but I will just emphasize that the history of the decisions that led up to Higgins, that led through Southeast Floating Docks, make it pretty clear what the holding in Southeast Floating Docks is and the breadth of that holding. Because before Southeast Floating Docks, you had the cases like Bennett and BDO Seidman. Those cases were not cases involving contractual choice of law provisions. One was an accounting malpractice case and the other was a securities fraud case. Both of those considered 768.79 to be procedural. One of them actually distinguished, or not distinguished, but disagreed with an 11th Circuit opinion that found that 768.79 was substantive for choice of law purposes, and that was the reasoning that led, I believe, Bennett to reach the conclusion that 768.79 could apply even where the substantive law of another state applied to the claims in the case. So when Southeast Floating Docks considered the question that was presented to us, could that be true? Could you have 768.79 apply with the substantive law of another state applied? It was taking on that very question and put the decision together in this very simple order. The very first question was, in their mind, to answer this question, is it substantive law for choice of law purposes? And by answering that question, yes, it is substantive law, it dispensed with the question, can I ever apply the substantive law of another state with 768.79, where if none of the claims are governed by as in this case, if none of the claims are governed by Florida law, can we ever apply 768.79? There is no precedent, not certainly at an appellate level decision after Southeast Floating Docks, that opens the door for such an interpretation. Higgins, I believe, binds this court, or stare decisis in this court, and is a rather short opinion because it sees the plain logic of that ruling or holding in Southeast Floating Docks. There's no real discussion needed. I think the lawyers in Cannon probably raised the same arguments that are being raised today, so the court entertained that discussion, but ultimately looked at the very same language that we've all seen already, that in Southeast Floating Docks, it said that court rejected the reasoning of Bennett and BDO Seidemann that would look at this plain language of the statute as applying to any civil action for damages filed in Florida court, and said, but it doesn't say even if the substantive law of another state applies. And because it doesn't say that, the Florida Supreme Court essentially said it never would apply. Now, I haven't heard a model or idea or legal principle that would override in any way how you could apply 768.79 once you have determined, or once the court has determined, as it has in this case, that Delaware law applies to every claim in this case.
Well, I think we have to start with the presumption that the plain language of the statute applies. And then we have to ask ourselves, why are we dispensing with that plain language? And I think your opposing counsel's argument is we dispense with that plain language when there is a contract to do so and not otherwise.
And that's why I go back to the Supreme Court in Southeast Floating Docks, when it rejected the reasoning of BDO, Seidemann, and Bennett. It was rejecting that reasoning as applied to cases that did not involve contractual choice of law provisions. Those cases involved tort claims or accounting malpractice and securities law.
But applying that principle to those cases and directly addressing the issue of whether or not the contractual aspect of it versus the which law applies otherwise aspect of it, what was controlling, that doesn't answer the question. The fact that a case may have happened to apply to those other cases without the issue being raised doesn't create precedent.
Well, I feel like the Supreme Court in Southeast Floating Docks did not limit did not find that the plain language of 768.79 always applied other than in this narrow exception for contractual choice of law provisions.
No. The idea that the statute always applies is our initial presumption. The narrow exceptions to that the Supreme Court may draw have to be read more narrowly, and I think you're trying to read it more broadly. The fact that we don't strictly read that plain language and apply it in every case doesn't mean we never apply it unless there's a reason to.
The reason to would be that the substantive law applies to the claims in the case. I believe that is the very purpose of Southeast Floating Docks first holding that 768.79 is substantive. When it reads and discusses or rejects BDO, Seidemann, and Bennett, the quote that it rejects is, and I believe you may have read, Your Honor may have read this, but the 5th District's opinion, I'm quoting now, the 5th District's opinion in Bennett merely agrees with the reasoning of the majority conclusion in BDO, Seidemann that, quote, Section 768.79 applies to all civil actions for damages brought in Florida, even where the substantive law of another jurisdiction is applied.
So answer me this. The cases do seem to lay out the possibility that one issue may be decided by foreign sensitive law, while another issue may be decided by Florida law, unless you have mixed provisions. How is it necessary to look at foreign substantive law to decide the question of whether a case was brought in a Florida court and is for damages?
I believe that you do ultimately, or the trial court ultimately does have to perform an analysis of what claims
How important it's for damages. So the question of whether it's for damages or not would probably be answered by the foreign law, but what's it brought in Florida court?
Sorry, what was the last part of that?
The question of whether it's brought in Florida court. Do we have to look to foreign law to answer that question?
I don't think you have to look to foreign law to determine whether it's brought in Florida court. I think you have to look at, in terms of whether to apply 768.79, you have to look at whether the foreign law applies to the claims in which the offer of judgment is being made.
So this idea that we make the automatic leap that any substantive law in Florida is precluded when we adopt foreign substantive law doesn't seem to be as absolute as I think you're making it out to be.
Well, I think it's absolute in the sense of does 768.79 apply if the foreign law is, I think if only foreign law claims apply to the case. I don't think that there's any question about that. The question of whether, I think your Honor's asking the question, well, might you look at whether the damages, whether a claim is brought for damages or is considered damages under that law is a claim for damages, but would you ever look at that question if it was only foreign law that applied, because 768.79 wouldn't apply for the very reason that it's a foreign law that applies. So I think if it's kind of difficult hypothetically, you probably have to have some claims that are governed by Florida law, some claims that are governed by a foreign state law, and then you would, in that scenario, have to look at whether I think even in that case, you have Florida law applying to certain claims, 768.79 would apply. So I'm not sure there's a scenario where you would only have to look at the question of damages under a foreign law, because the foreign law would be the exclusive substantive law that applies, in which case 768.79 would not apply for that reason alone, and it wouldn't matter whether it was equitable or non-equitable or a combination of claims. But that's off the top of my head considering that hypothetical. I do come back to the idea that would Diamond Aircraft also preclude this claim, and counsel for the appellant named or identified some series of harms or damages or anything, but obviously this is a claim from the estate, and the estate has never really suffered any damages.
And that seems on its face to be true, but how do you deal with their argument that there is an exception to that exclusivity for damages when the true case is about damages? And essentially what their argument is, pay all whatever they want the money.
Yeah, so it's about money, but it's not about damages. I mean, this is not a case about where somebody had suffered an injury and there's a recovery for that injury. This is a case in which the Delaware Supreme Court, which by the way,
what about the really, really broad reading I discussed earlier? I'm being deprived of the money that I'm entitled to, therefore I am damaged.
I couldn't say off the top of my head whether that type of damage would satisfy the 768.79 concept of damages. It's my recollection, though, that it is intended to cover true damages and not, anybody could argue statutory penalties were damages in such a scenario, which I don't think would qualify. I also don't think equitable claims for money would qualify for such a recovery under Diamond Aircraft, as we just talked about. So I think it's very specific and narrow in the form of damages as remuneration for a harm that is suffered by a victim. And in that sense, that's not what we're talking about here. For that reason, I would submit that this does not apply here. I don't know that I need any additional time. I'm happy to answer any questions that the court may have for me. Thank you very much.
So I do just want to touch on one thing that counsel had just said, that when there's mixed claims and the application of both Florida law and a different state's law would apply, that then the offer of judgment statute would apply. is that what I believe he said. And in that instance, there isn't much of a distinction between that and the instance in our case where litigation has gone on for years, and it was only at the tail end of the litigation that the lower court decided to apply Delaware law to the underlying claims. And I also want to touch on damages. Again, just to make clear that nothing within counsel's argument identified how what our claim is here isn't damages under Diamond Aircraft, and the other cases that are cited to within its briefing don't support its point either. As we mentioned, these are recycled arguments that the other side likes to make in a variation of different contexts in our cases, and I point you to the Bogus case that we cite to in our papers to show how courts have found that there are damages here and injury. Unless there's any other questions,
So you've made a couple of arguments, the plain text argument, public policy argument. Give me a roadmap of how we get to where you want us to go. Because there hasn't been any really solid, I'm struggling to see how we parse this out in a meaningful way. And I understand what the case law says, but what are the foundational concepts that are going to get us to where you're asking us to go?
Sure. So we have to start with the plain language of the statute here, which says that it applies in any civil action for damages filed in this state. So if we take that language, it means that if we're in Delaware court, which we are here, that the offer of judgment statute applies. In Southeast Floating Docks, the Florida Supreme Court found a narrow exception where the parties have agreed to be bound by the substantive law of another state through a choice of law provision. But there is no choice of law provision here. And so absent that, the offer of judgment statute is still available to litigants who bring claims in Florida courts, regardless that other claims in the case eventually have the substantive law of another state apply. And I think in finding this, it's important to know the public policy that the Florida Supreme Court mentions in Southeast Floating Dock when it's found that that choice of law provisions aren't, you're not able to get the offer of judgment statute. And they talked about how the freedom of contract and the public policy behind that outweighs the offer of judgment statute. That's not present here. And I see I'm over, so unless there's any other questions, thank you.
Thank you to both. That was well presented on both sides. As I said at the beginning, we'll take about a 10-minute break. So the court will be in recess until 10:25.
All rise.